Welcome to our lecture on the fundamentals of prosecution of crime, serving as a prosecutor and defense lawyer's guide. This is just a brief introductory outline of those fundamental principles. We are going to have more discussions, in-depth discussions on almost all the issues and concepts that are covered in this discussion. I hope that you find it very useful for your studies and for just general knowledge. Now, these are the resources that you will have to make use of and constantly refer to, particularly Criminal Procedure Act 51 of 1977, because South Africa's criminal procedure is actually based on that act, and it reflects all or main aspects of that Criminal Procedure Act 51 of 1977. So you must keep it close to you. It must really be a close friend as you study the material. And of course, there are other legislations to think about, such as the Firearms Control Act of 2000, the Drugs and Drug Trafficking Act 140 of 1992, just among others. And then you'll also have to revisit the principles of criminal law and then principles of the law of evidence as well. So those are some of the things that you must keep in mind and keep close to you. Now, looking at a prosecutor and a defense lawyer's basic toolkit, you must understand that the principles of criminal law, which are feature as part C of the prosecutor's module, and then the knowledge of criminal procedure, which serves as part 2, as well as the knowledge of the principles of evidence serving as part A. They are actually the main components, the main laws that you need to really maintain knowledge of. For instance, you will notice that criminal procedure is actually a procedural aspect, whilst we have criminal law, which is a substantive, or rather a branch of substantive law, and then principles of evidence, which are also in a way adjectival. So you must remember that these three work hand in hand. Now, I decided to commence the discussion by looking at the principles of criminal law for the reasons that will be revealed as we go on to our next slides. Now, this is how the elements of the toolkit relate to each other. You find that the principles of criminal law determine what conduct constitutes a crime. It is in terms of the principles of criminal law that a crime is defined, by outlining the definitional elements of what constitutes that crime. And once conduct satisfies the criteria of criminal conduct, then steps must be taken to punish crime through invoking of the rules of criminal procedure. In other words, the rules of criminal procedure are corrective in nature. They are meant to correct whatever violations may have resulted from criminal conduct. And in order to prove that a crime has been committed, the principles of the law of evidence are then applied and used to determine what evidence is relevant to prove the commission of the so-called offense, and how the evidence is gathered and presented in court, as well as the weight that is attached to it. That is the weight that is attached to the evidence. And of course, taking into account that there are different types of evidence. So it is very important to always give yourself a holistic view of how the principles of criminal law relate with the principles of criminal procedure, and then how the evidence is used in order to prove that an offense has been committed. It's very, very important to always maintain that knowledge of the relationship because it's very critical. So maybe just an extended view on the principles of of criminal law. We have sources of criminal law that you must familiarize yourself with. Of course, they don't constitute the major part of this study, but you can't do well in criminal procedure if you don't already know the important aspects of criminal procedure. So you get knowledge from, you get the knowledge about criminal law from common law, from statutory law, is very important sources. And then for the purposes of, serving as a prosecutor or as a defense lawyer, you must understand the elements of a crime. You must understand the issues because those are the issues that are reflected in a charge sheet or an indictment in terms of section 84 of the Criminal Procedure Act 51 of 1977. So you really need to know what conduct constitutes a crime, what are the elements of that crime, because in drawing the charge as a prosecutor, you will have to take into account those important aspects of criminal law, the definition of the crime, and so on and so forth. You must also familiarize yourself with the defenses excluding unlawfulness and all other defenses that are available to a person who's been charged with a criminal offense. Because whilst as a prosecutor you will want to push for the conviction of the accused, you must take into account and remember that the accused is also going to be invoking some defenses. So you really need to know what those defenses are. And without adequate knowledge of what the defenses are, you will not go far enough in terms of, securing any successful prosecutions and convictions. So thinking now about elements of a crime, you have to understand that a crime consists of a voluntary human act or conduct. It could also come in the form of an omission where a legal duty is owed. We will explain that as we go further with the discussion. And then you must also take note of the principles of causation and causality, and then elements of unlawfulness. What about issues of fault, where you are thinking of whether the act was committed intentionally or negligently? What is often called the culpability element, maybe often expressed as actus reus or mens reus in Latin. So then you talk about participants in crime. Who participates in crime? We have different kind of participants. We've got accomplices and we've got accessories after the fact, and all those role players in the commission of a crime. We must understand how the law deals with them. And then we will also extend to look at some selected statutory offenses, just to illustrate how these principles operate in real life. So still thinking about criminal procedure, which is the other leg of our discussion. Remember I said we've the principles of criminal law. Now we are looking at criminal procedure, and from here we will then look at principles of evidence. So looking at criminal procedure, we are looking at the power to prosecute. Who has power to prosecute? Who is endowed with the power to prosecute? So the statutes actually confer these powers to somebody called a prosecutor, who can prosecute or also exercise the power to withdraw prosecution. And we will also be looking at entering premises to search for and seize evidence. That is how the police and all persons, seized with the duty and the responsibility to seize, to gather evidence, how they enter premises of suspects. And then you also look at methods of securing the attendance, of the accused to court. How do we ensure that the accused comes to court? And then what procedure is followed after the arrest of the accused? And well, there are methods to bring the accused to court through the summons to appear before a magistrate's court. And then we also have to think broadly about the consequences of a failure by the accused to appear as summoned. And of course, we will also look at the admission of guilt procedures, which actually then bring the prosecution process to an end, because once an accused admits guilt and pays a fine in some of these minor crimes, then a criminal record is made against the accused, and then the process ends there. Still on criminal procedure, there are a lot of issues to think about. Bail application by the accused. What rights does the accused have? And then in the process of applying for bail, what factors are considered? What are the powers of the state or the powers of the prosecution in terms of responding to bail applications? Who can amend bail conditions and under what circumstances? And how about bail cancellation? Does bail get cancelled at some point? What happens if an accused who is on bail fails to appear in court? Does it then lead to a bail a cancellation? And what are the necessary circumstances warranting a cancellation of bail? And think also about summary trial procedures, which are still part of the criminal procedural process. And then we'll look at the charge sheet and the proof of the record of the criminal case, panel for purposes of the inquiry, and then the joinder of charges. If, for instance, a person commits several acts which may be related or unrelated, and then the prosecution may decide to charge that accused in one charge sheet where all the charges are brought together under that one umbrella of a charge. So that's what we call the joinder of charges. Of course, we will look at the essentials of a charge as reflected in Section 84 of the Criminal Procedure Act, and then how the accused responds to the charge. The accused may object to the charge, may demand an amendment to the charge, and so on and so forth, may even demand that the court orders a delivery of particulars, maybe clarification by the prosecution. We'll also want to understand how the law deals with the aspect of a defective charge. Those are issues that we will very much dwell on. There's the issue of the plea. Once an accused is charged, once a person is charged, then automatically their right to respond by way of a plea it comes into effect. In other words, the accused must then be brought before a competent court of law where he or she can make a plea, either plead guilty or plead not guilty, and then the accused may also respond maybe by way of questioning the jurisdiction of the court. So in other words, the prosecution must ensure that the accused is arraigned before the right court which exercises jurisdiction. to ensure that the accused is rightfully before the court. Otherwise, the case may actually be, it may actually be ended or terminated, if what we say, when the accused is brought before a court that doesn't have jurisdiction. And then there are issues of committals of accused. For instance, an accused may be found guilty in a court, but may then be sent to a court with a superior jurisdiction, maybe from a magistrate's court to a regional court for prosecution, maybe just because the other court, the first court or the court of core, does not uh, command sufficient or adequate jurisdiction or the authority to handle or to deal with that kind of a case or the accused person. And then there are issues now of the prosecutor addressing the court to adduce evidence, and then sometimes two or more accused may be joined together in what is called a joinder of the accused, or their trials may be separated. And during the process of tendering evidence, you find there is issues of cross-examination, re-examination of witnesses, and then those are issues to do with how evidence is presented, but we will deal more with issues of evidence later on. And then court's power to adjourn proceedings and to any place and any time. You see, these are the powers of the courts that must be understood by the court, by the prosecutor. What are those powers? What is it that the court is capable of doing or not doing? Can it adjourn the proceedings at any time and to any place? That's very important to understand. Then there is also the issue of what is called absolution from instance, whereby the accused may be discharged at the close of the state case. In that criminal procedure case, where you find that the state or the prosecution present their evidence before the court, that is after the accused has made a plea, and then it may turn out that the accused believes or is of the opinion that the state has failed to prove a prima facie case against the accused, and therefore he says, let me be acquitted before I plead, or rather before I present any evidence. Remember, the plea of course would have been done earlier. So in this case of absolution from instance, the accused is actually claiming a discharge from the charges laid against him or her, on the grounds that the state has not proved any case, or rather any the commission of any offense. Therefore, it has not made a prima facie case against the accused, who then gets to be entitled to an acquittal without even giving evidence. So you find prosecution and defense may address the court at the conclusion of the case. So that's the role of the prosecution. In other words, the prosecution and the defense lawyer must always be ready to and prepared to eloquently and clearly address the court on very important matters. And then there's also the issue of the presentation of various forms of evidence. We will look at the different forms of evidence and how they are used. And also, remember, it is also the duty of the prosecution to advise the court about the nature of the sentence that they are praying for as prosecution. So that's very important to think about. Having spoken about principles of criminal law, principles of criminal procedure. Now we move on to look at the principles of evidence, whereby we are looking at facts in issue. What are the facts that have to be proven? What are the facts that are relevant to the facts in the issue? What is called facta probantia and facta probanda. And then we have to look at the evidence and the probative material that is necessary to prove whatever allegations are made in the charge. And then think also about the criterion of relevance. How relevant is the evidence that is being accused or presented? And is it admissible in the court? Because there are rules on the admissibility of evidence. We will have to look at them on that section that deals with evidence. It's not all evidence that people encounter which would be admissible in court for several reasons, which we will discover as we look at admissibility. What about the weight of the evidence that has been presented? Does it sufficiently, prove the claims being made? Yes, of course, thinking then about direct and circumstantial evidence and the weight of evidence, the weight attached to each one of those. Thinking also about primary and secondary evidence, and also concerning ourselves with the hearsay evidence and whether it does have any place at all in the as evidence to be considered by the court. And then there are admissions and confessions, which are also very, very important, because sometimes the accused may admit to certain facts and may even confess to having done certain things or acted in a certain way. So all those issues are very, very important aspects to be taken note of. So thinking here about the kinds of evidence and the methods of its presentation, one is immediately reminded that there is oral evidence which is presented in the through the stages, such as provision of evidence in chief, when the prosecution opens the state case and outlines what the accused is being charged with, as well as the available evidence. And then there's cross-examination and re-examination. We'll also be able to look at real evidence. What do we mean by real evidence? We could be talking about blood samples or DNA and so on and so forth, or written records in some instances, maybe a letter or a diary written by somebody, one person to another. Now that's real evidence. And then we have documentary evidence, we have electronic evidence, and there are laws also to do with this electronic evidence, for instance the Electronic Transactions Act. And then witnesses. It's very important to also think about witnesses. Who can be a witness and who is not a competent witness? So we think about competence and compellability of witnesses. It's not everybody who may actually be subpoenaed and compelled to give or to testify, even if they are aware. For instance, competence and compellability then become at the center, as you would think about spouses not being compelled to testify against each other, except of course in certain circumstances, like in cases where maybe there is abuse of their minor children and so on. Maybe those are the only exceptional circumstances where one spouse may then be compelled to testify against the other. Otherwise, spouses remain competent but not compellable and so on. So those terms of compellability and competence will have to be clearly understood. And then there is issues of the evaluation of evidence, which is often done by the court. But the prosecution and the defense must have understanding of how the court would arrive at its decision. So the evaluation of evidence then becomes a very critical thing to think about. And then the standard of proof in criminal trials. uh, in civil trials, they can be, there is usually an application of proof on a preponderance of probabilities. But in criminal law, criminal cases, it's always proof beyond reasonable doubt. So that standard of proof is very, very important. It must be understood. And then there are also issues of the onus of proof. Who bears the onus of proof? Who must discharge that onus in order that the court may make a finding on the basis of, in terms of the charges that have been laid against the accused. Thank you very much for being part of, listening right through to the end. This lecture is considered an introduction to the fundamental aspects of the criminal prosecution process in South Africa. It has demonstrated that the principles of criminal law dovetail very well with the rules of criminal procedure and the fundamental principles of the law of evidence. It has laid a foundation for a deeper study of the fundamentals of criminal prosecution. So it's very, very important that you take note of what has been covered here, because your understanding of this lecture is actually laying a foundation for your study as you proceed and go to the next stage. I hope that things will now become clearer as you then go to each one of the sections that we have highlighted here. Thank you very much. May God bless you.